In less than 5 minutes, a ruthless federal magistrate attempted to destroy Marlene Jefferson with a crushing $200,000 penalty. No evidence was presented. No proper hearing was conducted. Just raw, unchecked power being wielded like a weapon against a woman who dared to stand her ground. But here's what he never anticipated. That single act of arrogance would become the catalyst for his own spectacular downfall. What should have been a mundane administrative proceeding in a dusty courtroom in downtown Atlanta transformed into a legendary battle between institutional tyranny and unyielding courage. Can a black woman armed with nothing but her knowledge of the law and unbreakable determination bring an entire corrupt system crashing to its knees? Stay with me through every moment of this incredible journey. This is a story that will stay with you long after the final word. Before we go deeper into this story, take a second and hit that subscribe button. Give this video a like, and let us know where you're watching from. I'm curious to know how far these stories travel. It was a bone-chilling Tuesday morning when the winter sun cast long shadows across the marble floors of the Jackson County Federal Courthouse. Courtroom 7B was scheduled for what everyone assumed would be a routine compliance review, the kind of forgettable proceeding that gets buried in docket footnotes and never spoken of again. The old radiators clanked and hissed in the corners, struggling to warm the cavernous space against the February chill that seemed to seep through the very walls. The American flag hung motionless beside the Georgia state banner, both appearing oddly subdued beneath the harsh fluorescent lighting that buzzed overhead. But the moment Marlene Jefferson stepped through those heavy oak doors, every instinct she had developed over 15 years of practicing law screamed that something was terribly wrong. Marlene was no ordinary attorney. She had spent a decade as an assistant federal prosecutor in the Southern District, handling everything from white-collar fraud to civil rights violations. She had cross-examined witnesses who thought they could lie their way to freedom. She had argued before skeptical juries who needed convincing. She had stood her ground against defense attorneys who tried every trick in the book to undermine her cases. After transitioning to civil rights litigation 5 years ago, she had taken on some of the most powerful institutions in the state: insurance companies that denied legitimate claims, corporations that discriminated against minority employees, government agencies that overstepped their authority. She had won more cases than she had lost, and the losses had taught her more than the victories ever could. All of that experience was now sending urgent warning signals through her nervous system. The silence that greeted her wasn't the respectful hush of judicial decorum. It was something far more ominous, calculated, deliberate, suffocating. The court staff refused to meet her eyes. The bailiff, a man named Gerald Patterson, with whom she had exchanged pleasantries on numerous occasions over the years, stood rigid against the far wall, his gaze fixed somewhere in the middle distance. His hand rested on his belt, not near his weapon, but in a posture of practiced disengagement, as if he had decided before she arrived that whatever happened, he would see nothing. Even the ancient radiators seemed to have stopped their usual clanking, as if the building itself was holding its breath, waiting for something terrible to unfold. The gallery behind her held perhaps 24 observers, junior attorneys from various firms looking for courtroom experience, a few law students scribbling notes for classes they would never complete, and several older men in expensive suits whose presence seemed both coincidental and deliberate. One of them, she noticed, was taking notes on a yellow legal pad with unusual intensity. Then she saw him. Judge Theodore Harrington sat enthroned behind the elevated bench, his silver hair swept back from a face that seemed carved from granite. Deep lines etched his forehead and bracketed his thin-lipped mouth, each one a monument to decades of wielding power without accountability. He was known throughout the Georgia legal community as the Hammer, a man who dispensed rulings with cold efficiency and suffered no challenges to his authority. Defense attorneys whispered about his tendency to make decisions before hearings even began, treating due process as an inconvenient formality rather than a constitutional mandate. Prosecutors loved him because convictions came easy in his courtroom. Civil rights advocates feared him because justice seemed an afterthought when he presided. His eyes tracked Marlene as she approached the defense table, but there was nothing judicial in his gaze. He wasn't looking at her like an officer of the court examining a colleague. He was looking at her like a predator sizing up prey, like an obstacle to be eliminated, like something that had wandered into his territory and needed to be reminded of the natural order. Marlene set her leather briefcase down with measured precision, refusing to let her hands tremble, despite the electricity crackling through her nervous system. She had walked into traps before, in courtrooms far more hostile than this one, but never one that felt quite so carefully constructed, so deliberately designed for her specific destruction. The prosecution table sat empty, which struck her as unusual, for what was supposed to be a contested hearing. Where was opposing counsel? Where were the case files that should have been spread across the lacquered surface? Where were the witnesses waiting to testify against her? The absence was itself a message, a declaration that whatever was about to happen had been decided long before the doors opened. This wasn't going to be a hearing. It was going to be an execution. Judge Harrington entered the proceedings without the traditional courtroom rituals. There was no bailiff announcement calling everyone to rise. There was no standing for his arrival, no acknowledgement of the assembled parties, no reading of the case number and parties involved. He simply materialized behind the bench as if conjured from the shadows themselves, already seated, already in command, already rendering judgment. When he spoke, his voice carried the weight of absolute authority, low and clipped, devoid of warmth or hesitation, or any recognition that the woman standing before him possessed rights that he was constitutionally bound to respect. "This matter has been thoroughly reviewed by this court," he announced, his words falling like hammer blows on an anvil. "The defendant is found in violation of Municipal Ordinance 47C regarding commercial property standards and administrative compliance protocols. The penalty is assessed at $200,000, payable within 30 calendar days. Failure to comply will result in additional sanctions, including potential incarceration for contempt. This court is adjourned." The declaration landed like a bomb in the center of the courtroom, sending shockwaves through every person present. Marlene felt her heart seize in her chest, felt the blood drain from her face, felt her knees threaten to buckle beneath her. $200,000. For what alleged violation? Based on what evidence? Through what procedural process? She hadn't uttered a single word. Her case files remained closed in her briefcase. She hadn't been given the opportunity to present arguments, call witnesses, cross-examine accusers, or challenge any finding. The judge had simply pronounced judgment as if the entire proceeding were a predetermined theatrical performance, and she was merely an unwitting actor playing her assigned role as victim. Even the court reporter, a weathered woman named Dorothy Chambers, who had transcribed thousands of hearings over her 30-year career, looked up from her stenograph machine with undisguised confusion and something approaching horror. Her fingers hovered motionless over the keys, uncertain whether to record what seemed impossible to believe, what violated every principle of judicial procedure she had ever witnessed. The attorneys in the gallery exchanged bewildered glances. A few shifted uncomfortably in their seats. One of the younger lawyers, a woman who couldn't have been more than a year out of law school, had her mouth hanging open in naked disbelief. She would later describe this moment as the one that transformed her understanding of how power could be weaponized within the very institutions designed to prevent such abuse. For a long, excruciating moment, no one moved. The silence had transformed from tense to suffocating, the air itself seeming to thicken with the weight of what had just transpired, the magnitude of the violation that had occurred in plain sight before dozens of witnesses who seemed powerless to respond. This wasn't a courtroom anymore. It was an execution chamber, and Marlene had been sentenced without trial, convicted without evidence, condemned without any opportunity to speak in her own defense. But Marlene Jefferson had not survived 15 years in the legal trenches by folding under pressure. Something inside her crystallized in that moment, a fusion of outrage and determination that would fuel everything that followed. The fear she felt transformed into something harder, sharper, more dangerous. She had seen this before, not directed at her personally, but at countless defendants who lacked the knowledge or resources to fight back. She had watched judges railroad defendants who couldn't afford attorneys. She had seen prosecutors pursue charges they knew were baseless. She had witnessed the machinery of institutional power crush individuals who dared to stand in its way. But she was not those defendants. She was not powerless. She was not ignorant of her rights. And she was not going to be silenced. She rose slowly from her chair, her movements deliberate and controlled, despite the adrenaline flooding her system. Her spine straightened, her shoulders squared, her chin lifted to meet the judge's hostile gaze with unwavering directness. "Your Honor," she said, her voice cutting through the silence with surgical precision. "With all due respect to this court and to the judicial authority vested in your position, we have not begun. I have not been permitted to present a single argument in my defense. I have not been shown the evidence supporting this judgment. I have not been given the opportunity to cross-examine any witnesses or challenge any findings. What has just occurred is not a hearing. It is a violation of fundamental constitutional protections." Harrington's eyes narrowed, not with reconsideration, but with naked irritation. He was not accustomed to defendants who failed to accept their designated role as victims. He was not familiar with women who spoke back to him with such clarity and conviction. His face flushed with the anger of someone whose authority has been publicly questioned. "Counsel," he replied, the word dripping with condescension and barely concealed contempt. "The violation is documented in official records. The penalty is assessed according to established municipal guidelines. There is nothing to debate here, and your theatrics will not change the outcome of these proceedings." His tone wasn't merely dismissive. It was deliberately humiliating, designed to remind everyone present who held the power in that room. "Sit down. Accept your punishment. Know your place. Remember who controls your fate and who controls nothing." If you were in Marlene Jefferson's shoes right now, facing a judge who had already decided your fate before you could speak a single word, what would you do? Would you accept the injustice and walk away defeated? Or would you stand your ground and fight back against overwhelming power? Share your thoughts in the comments below, because I genuinely want to know how you would handle a moment like this. Marlene remained standing. Her hands, which moments ago had threatened to shake with barely contained rage and fear, now rested calmly on the polished surface of the defense table. Every movement she made was calculated, precise, radiating the kind of controlled power that comes from years of courtroom experience and the hard-won knowledge that composure is a weapon more effective than anger. Her heart might have been pounding beneath her charcoal blazer, might have been beating so hard that she could feel it in her throat, but on the outside she projected absolute stillness, absolute certainty, absolute refusal to be intimidated. She had learned long ago that in a courtroom where power is being abused, visible emotion becomes a liability that opponents will exploit without mercy. Every tear becomes evidence of weakness. Every raised voice becomes grounds for sanction. Every trembling hand becomes confirmation that the target is breaking under pressure. But restraint, properly wielded, becomes a different kind of weapon. Composure, in the face of abuse, makes the abuser look unhinged by comparison. Calm precision exposes the irrationality of those who rely on intimidation. And steadfast dignity reminds everyone watching that truth does not need to shout to be heard. "Your Honor," she continued, her voice gaining strength and resonance with each word, "I am formally invoking my constitutional right to due process under the 5th and 14th Amendments to the United States Constitution. These foundational protections guarantee that no person shall be deprived of life, liberty, or property without proper notice and meaningful opportunity to be heard. What has transpired here today constitutes a fundamental violation of those protections, a violation that this court will be held accountable for, regardless of what ruling you choose to issue." Her words sliced through the oppressive atmosphere like a blade through fog. She wasn't pleading for mercy. She wasn't asking the judge to reconsider out of kindness or compassion. She was invoking rights that predated Judge Harrington's career, rights that predated the courthouse itself, rights that could not be swept aside by judicial fiat or personal hostility. The gallery had gone completely still. The young attorneys who had come seeking routine courtroom experience were witnessing something far more valuable, a masterclass in constitutional advocacy, delivered under the most hostile conditions imaginable. Harrington's jaw tightened visibly, the muscles working beneath his weathered skin. His fingers, which had been drumming impatiently on the bench in a display of contempt, went completely still. He leaned forward, both elbows planted on the polished wood, his eyes boring into hers, with undisguised hostility, and something that might have been the first faint stirrings of concern. "Miss Jefferson," he said, his voice dropping to a dangerous register that had silenced countless defendants before her. "This is my courtroom. I will not tolerate grandstanding, delay tactics, or attempts to transform these proceedings into political theater. The matter has been decided according to established procedures. You may take your concerns to the appellate court, assuming you can afford to do so after this judgment is enforced." The threat was unmistakable, delivered with the casual cruelty of someone accustomed to destroying people without consequence. He wasn't just ruling against her. He was attempting to crush her financially and professionally, to make an example that would discourage any future challenges to his authority, to demonstrate that resistance was not merely futile but catastrophically costly. But in his arrogance, Judge Harrington had made a critical miscalculation that would prove his undoing. He had assumed that Marlene Jefferson was like the countless other defendants who had stood before his bench over the years, intimidated into silence, overwhelmed by the machinery of institutional power, lacking the knowledge or resources to mount an effective defense. He had no idea who he was dealing with. Marlene reached into her briefcase and withdrew a folder that she had prepared for precisely this moment, for exactly this kind of judicial overreach, for the day when someone in power would attempt to strip her rights without regard for law or precedent. The movement was unhurried, almost casual, but the impact on the courtroom was immediate and electric. The silence shifted from oppressive to anticipatory, like the hush before a symphony's opening note, like the held breath before lightning strikes. "Your Honor," she said, her voice steady as tempered steel, "since this court has chosen to dispense with normal procedural requirements, perhaps we should discuss legal precedent, because what you are attempting to do here today has already been judged by higher authorities, and I should inform you that it did not withstand scrutiny." She opened the folder with deliberate precision and held up the first document, allowing everyone in the gallery to see the official seal of the United States Court of Appeals at its top. The seal seemed to glow under the fluorescent lights, a symbol of authority that superseded anything Judge Harrington could claim. Richards versus the City of Montgomery, decided by the 11th Circuit Court of Appeals in 2018. The defendant in that case was assessed a substantial fine under circumstances virtually identical to the situation before us today. No photographic evidence of any violation was presented. No independent corroboration from any witness was provided. No opportunity for the defendant to contest the underlying findings was granted. Just an official's assertion treated as incontrovertible fact. She let the information settle over the courtroom like falling snow, soft but inescapable. The appellate court found the process unconstitutional and reversed the judgment in its entirety. Not modified, not reduced. Reversed completely, with the city ordered to pay all legal costs and damages to the defendant they had wrongfully punished. She continued, her eyes never leaving Harrington's face. In its written opinion, the court stated, and I quote, "Where punitive measures are imposed without adequate evidentiary foundation, due process is not merely compromised. It is extinguished entirely. Administrative convenience cannot supersede constitutional mandate, regardless of the administrative burden that proper procedure may impose on government actors." The atmosphere in the courtroom had undergone a seismic shift that everyone present could feel in their bones. What had begun as a one-sided execution, a predetermined slaughter of rights and dignity, was transforming into something far more dangerous for Judge Theodore Harrington, a public dismantling of his authority, witnessed by fellow attorneys who would carry the story of this day throughout the legal community. Marlene turned to her second document, her movements measured and deliberate, like a surgeon selecting the next instrument needed for a delicate operation. Patterson versus the City of Jacksonville, decided in 2020 by the same appellate circuit. Another case where a municipal fine was levied based solely on an official's personal assessment. No photographs documenting any violation. No timestamps establishing when the alleged offense occurred. No physical record of any kind, beyond the word of the enforcement officer. She paused, letting the parallel between that case and her own situation sink into the consciousness of everyone listening. The city argued, as I suspect would be argued here, that standard enforcement practice made such documentation unnecessary, that officials should be trusted to report accurately, that requiring evidence would place undue burden on municipal enforcement capabilities. Her voice sharpened. The court disagreed, forcefully and unanimously. She read directly from the document. In its ruling, the court stated, administrative authority exists within constitutional bounds, not above them. Penalties levied against citizens must be grounded in verifiable fact, or they are void upon judicial review. No convenience of bureaucracy, no efficiency of process, no claim of expertise can substitute for the fundamental requirement that punishment be based on proof. Judge Harrington's composure had begun to fracture visibly, like cracks spreading across a frozen lake. His jaw worked silently, grinding teeth behind thin lips. His fingers twitched against the bench in an unconscious display of agitation. He glanced toward the empty prosecution table, as if hoping someone would materialize to rescue him, then toward the door to his chambers, as if calculating whether escape was still possible. That ruling was upheld at every subsequent level of appeal, Marlene continued, her voice building to a relentless crescendo. Every single level, Your Honor, from the appellate court to the full circuit review. Would you like me to continue? Because I have 17 more cases in this folder, each one establishing the same fundamental principle that you have violated today. You cannot punish without proof. You cannot convict without evidence. You cannot destroy a person's livelihood on nothing more than your personal displeasure. For the first time since the hearing began, genuine uncertainty flickered across Harrington's face, like a shadow passing over the sun. He had expected compliance, not confrontation. He had expected fear and submission, not expertise and determination. He had expected Marlene Jefferson to crumble under his authority like everyone else who had stood in that spot. Now he sat trapped by his own overreach, watching his carefully constructed power play disintegrate before an audience of attorneys, clerks, law students, and court observers who would remember this day for the rest of their careers. Before we continue, take a second and share your thoughts so far on this story below. I read every single one of your comments, and they help me understand which stories resonate most deeply with this community. The court reporter's typing had resumed with renewed urgency, each keystroke capturing what was becoming a masterclass in constitutional advocacy. Her face had transformed from confusion to something approaching admiration as she documented testimony that would become legend. Young attorneys in the gallery leaned forward in their seats, their faces reflecting a mixture of awe and inspiration that would shape their entire careers. They were witnessing something rare and precious. Institutional arrogance meeting its match. Raw power being forced to answer to the law it claimed to serve. One of the older men in expensive suits had stopped taking notes. He sat perfectly still, his yellow legal pad forgotten, watching the proceedings with an expression that suggested he was reevaluating everything he thought he knew about this courtroom and the man who presided over it. Marlene pressed forward, sensing the momentum shift in her favor, like a sailor sensing the wind change direction. You assessed a $200,000 penalty against me without requesting any evidence to support the alleged violation, without allowing any argument in my defense, without conducting any hearing whatsoever. There is no documentation supporting this judgment, no testimony from any witness, no physical record of any kind. What you have is nothing more than an unsupported assertion, an exercise of raw power dressed up in judicial robes and constitutional language it does not deserve. She took a single step toward the bench, her presence commanding the room, her voice carrying to every corner with perfect clarity. And respectfully, Your Honor, that is not justice. That is authoritarianism wearing the costume of the law. It is tyranny hiding behind procedural language, and it will not stand. Not in this courtroom, not on this day, not against me. Judge Harrington's voice, when it finally emerged from his tightly pressed lips, had lost its earlier thunderous quality entirely. The words came clipped and forced, a transparent attempt to maintain authority that was rapidly slipping away like sand through desperate fingers. This court will recess for 15 minutes to allow for review of the procedural matters that have been raised. He rose abruptly, almost knocking his chair backward in his haste, and disappeared through the door to his chambers. His black robe trailed behind him like a flag of retreat, like the remnants of dignity fleeing from a battlefield where defeat had become inevitable. The bailiff scrambled to open the door, clearly unaccustomed to such precipitous judicial exits. His face registered the same confusion that gripped everyone else in the room, the recognition that something unprecedented was occurring. Marlene remained standing at the defense table, her expression carefully neutral. She understood exactly what had just happened. Harrington hadn't called a recess to reconsider the evidence or review procedural matters. He had fled to strategize, to make phone calls, to summon reinforcements for a battle he had never expected to fight. Somewhere in those chambers, she knew, he was frantically contacting allies, perhaps the district attorney's office, perhaps political connections who had protected him before, perhaps higher authorities who might intervene on his behalf. The question was whether any of them could salvage what had already become a disaster for his career and reputation. The courtroom buzzed with whispered conversations that rose and fell like waves against a shore. Attorneys exchanged glances heavy with meaning, silently communicating their amazement at what they were witnessing. The court reporter continued typing, capturing everything for a record that would eventually become legal legend, cited in law school classes and appellate briefs for decades to come. 20 minutes passed, then 30, then 45. The tension in the room ratcheted higher with each passing moment, each tick of the institutional clock on the wall seeming to mark the countdown to something explosive. When the chamber door finally opened, all eyes turned toward it with collective anticipation, like spectators at a sporting event watching the critical play unfold. Judge Harrington re-emerged, but he was not alone. Behind him walked a second figure, taller and considerably older, moving with the deliberate gravity of someone accustomed to wielding significant institutional power. His footsteps echoed through the silent courtroom with the weight of authority that transcended any single judge or proceeding. Chief Judge Winston Caldwell. The name rippled through the gallery in hushed whispers, spreading like wildfire among those who recognized him and those who quickly asked their neighbors for identification. Caldwell was a legend in Georgia legal circles, a former appellate justice appointed to oversee federal court administration for the entire Southern District. He had served on the bench for over 3 decades, accumulating a reputation for rigorous adherence to constitutional principles that made him both respected and feared. His presence in a routine municipal hearing was extraordinary, almost unprecedented. Judges of his stature did not typically appear for administrative proceedings. They did not descend from their elevated positions to observe lower court matters, unless something had gone seriously, catastrophically wrong. Marlene understood immediately what this meant. Harrington had called in the biggest gun available, hoping that superior rank and institutional authority could accomplish what flawed reasoning and abuse of power could not. It was a desperate move, the kind of escalation that revealed just how badly he had miscalculated, how completely he had lost control of a situation he had expected to dominate without resistance. Harrington resumed his seat at the bench, but something fundamental had changed in his bearing. His posture had contracted, his shoulders slumped slightly, his voice diminished to something far less commanding than before. He was no longer the unchallenged authority in the room. He had become, in the space of an hour, something closer to a defendant himself. "For the record," he announced, his words carefully measured, as if each one might be used against him. Chief Judge Caldwell has agreed to observe these proceedings and provide guidance on certain procedural questions that have arisen during the course of this hearing. The statement was technically neutral, professionally phrased according to standard judicial practice, but everyone present could hear the truth buried beneath the legal language. Harrington was drowning, and he had called for a life preserver from the only person who might have the authority to throw him one. Chief Judge Caldwell settled into a chair beside the bench, his silver-gray eyes sweeping across the courtroom with the practiced assessment of someone who had spent decades evaluating legal proceedings, detecting deception, and rendering judgments that shaped the course of justice. His face revealed nothing, but his presence alone changed the dynamics of everything that would follow. When his gaze settled on Marlene, she met it without flinching, holding the contact for a fraction longer than necessary. She saw intelligence there, and curiosity, and something that might have been the first stirrings of respect. This wasn't simply a courtroom anymore. It was a battlefield where institutional legacy faced reform, where entitlement confronted earned credibility, where decades of unchecked power met the immovable force of constitutional principle. Miss Jefferson, Caldwell spoke for the first time, his voice measured and commanding, carrying the weight of authority that came not from intimidation but from genuine mastery of the law. You have raised substantial constitutional concerns regarding the enforcement of Ordinance 47C and the procedures followed in this hearing. Please restate your core argument for the record, clearly and completely. It was a test, Marlene recognized immediately. A live audit of everything she had asserted, conducted by someone with the knowledge and authority to evaluate her claims with precision. She understood that her response would determine not just the outcome of her case, but potentially the future trajectory of administrative enforcement throughout the entire region. One misstep, one overstatement, one unsupported claim, and everything could collapse. But one precise argument, properly supported, could change everything. Marlene's hand rested gently on the leather folder that had become her most powerful weapon, the repository of truth that no amount of judicial hostility could overcome. She understood instinctively that this was the moment to shift from legal abstraction to human reality, to remind everyone present that constitutional principles exist to protect real people living real lives. Your Honors, she began, addressing both judges with measured formality and unmistakable respect. You have heard the constitutional framework that governs these proceedings. You have heard the appellate precedent that establishes the requirements for valid enforcement actions. But let us not pretend for a moment that this is merely about legal technicalities or procedural formalities. She paused, allowing her next words to carry their full weight. This is about people, real human beings with families and dreams and life savings. People whose lives have been devastated by the very practices I am challenging here today. People who deserve better from the system that was supposed to protect them. She withdrew a new set of documents from her folder, each one representing a story of institutional abuse that would echo through the courtroom long after the hearing concluded. Allow me to introduce you to Marcus Henderson, a Korean War veteran who served this country with distinction in one of its most brutal conflicts. He came home from that war with shrapnel permanently embedded in his leg, chronic pain that would never fully heal, and a dream burning in his heart to build something of his own. Marlene's voice carried genuine emotion as she continued, painting a picture that everyone in the courtroom could see. Marcus settled in Birmingham, Alabama, after his discharge. He used his life savings, accumulated over decades of disciplined frugality, to open a small auto repair shop in a working-class neighborhood. He worked 16-hour days rebuilding engines and transmissions, fixing problems that other mechanics said couldn't be solved. He helped fellow veterans who couldn't afford dealership prices, often accepting payment in the form of home-cooked meals or simple gratitude. She paused, letting the weight of the story settle over the courtroom. Last year, an enforcement officer determined that Mr. Henderson's shop was in violation of municipal signage regulations. The sign in question was hand-painted by his late wife, Margaret, 3 months before she passed away from cancer. It was his most treasured possession, his daily reminder of the woman he loved for 47 years. The silence in the courtroom had become absolute. No photographs were taken of the alleged violation. No measurements were recorded. No specifications were provided showing what exactly failed to comply. Just the officer's personal assessment that something looked wrong. Based on that assessment alone, the fine was $18,000. Marlene shook her head slowly. Mr. Henderson couldn't afford an attorney. He couldn't afford to take time away from his shop to fight the ruling. He couldn't afford the filing fees for an appeal. So he paid the fine by liquidating his retirement account, the money he had saved for 30 years against the day when his body could no longer work. 3 months later, he lost the shop entirely when he couldn't make his lease payments. She looked directly at both judges. 40 years of work, gone. A veteran's dream, destroyed. His wife's last gift to him, taken away. All because one person's opinion carried the force of law without any evidentiary foundation to support it. Before we go deeper, I would love to hear your point of view. Tell me what part of this story has hit you the hardest so far, and share your thoughts in the comments. These stories matter because your engagement helps us reach more people who need to hear them. Marlene turned to her next document, her voice steady despite the emotion underlying her words. Rachel Okonkwo, master electrician in Memphis, Tennessee, licensed for 15 years with a perfect safety record. 0 accidents, 0 violations, 0 complaints in a decade and a half of professional practice. She trained dozens of apprentices who went on to successful careers of their own. She ran her own crew and built a reputation for excellence that brought clients from 3 counties. The courtroom remained utterly silent, every person present leaning forward to hear what came next. Then the state changed its certification requirements without adequate notice to existing license holders. Suddenly, after 15 years of recognized expertise, her credentials were labeled non-transferable under revised municipal standards. Nobody could explain what that designation meant. Not the licensing board, not the administrative clerk, not the supervisor who stamped her file with the new classification. Marlene's jaw tightened. When Miss Okonkwo requested clarification, she was told the transition policy was internal and not subject to public review. When she filed formal appeals, they were denied without explanation. When she asked to see the specific regulation that disqualified her credentials, she was told that information was not available to members of the public. She eventually had to relocate to Florida and rebuild her career from scratch, starting again as if her 15 years of expertise meant nothing. 20 years of professional reputation, erased by bureaucratic caprice. A lifetime of hard work, dismissed by officials who never had to look her in the eye and explain their decision. Marlene's third case hit even harder. William Turner, retired truck driver, 64 years old, living outside Austin, Texas, on a small plot of land he purchased with his pension. After decades of driving 18-wheelers across the country, sleeping in truck stops and missing his children's birthdays, he finally had a place he could call his own. She described the scene with vivid detail. He built a cedar fence around his property with his own hands, cutting each board, setting each post, working through the brutal Texas summer because he couldn't afford to hire anyone. That fence extended 19 inches past the city's property line boundary. She let that number hang in the air like an accusation. 19 inches, less than 2 feet. The city assessed a fine of $15,000 for encroachment on public property, claiming his fence constituted a permanent illegal structure on municipal land. When Mr. Turner requested a professional land survey to verify the boundary location, he was told that the matter had already been administratively determined, and no additional review was available. When he asked to see the survey that established where his property ended and public land began, he was told those records were internal documents. Marlene's voice dropped to almost a whisper, forcing everyone to strain to hear. He couldn't afford legal representation. He couldn't afford an appeal. So he spent 2 days in the 100-degree Texas heat, tearing down the fence he had built with his own hands, the symbol of everything he had worked his entire life to achieve. The courtroom had become a vacuum of shared disbelief. On the third day, they find him again, this time for incomplete demolition, because some of the fence posts were still embedded in the ground. Another $5,000, assessed without inspection, without measurement, without any documentation, beyond the word of the same official who had issued the original citation. Marlene turned her full attention to the bench, her voice rising not in anger, but in conviction, carrying the weight of every person whose story she had just told. These are not isolated incidents, Your Honors. These are not aberrations in an otherwise fair system. These are symptoms of a systematic failure, a pattern of institutional abuse that has been allowed to flourish because those in positions of power assumed they would never be challenged, never held accountable, never forced to justify their decisions to the people they are supposed to serve. She gestured toward the empty prosecution table with controlled precision. Where is the evidence supporting the penalty against me today? Where are the photographs documenting the alleged violation? Where are the inspection reports detailing the specific failures? Where are the witness statements corroborating the official findings? Where is anything beyond the unsupported assertion of an official who may have had any number of reasons, legitimate or otherwise, for targeting me specifically? Her eyes locked with Chief Judge Caldwell's. There is nothing, because nothing exists. What we have before this court is one individual's uncorroborated opinion being treated as established fact, being given the force of law, being used to demand $200,000 from someone who has never been shown a single piece of evidence supporting the claim against her. She paused, her eyes locking with Chief Judge Caldwell's wise, weathered gaze. $200,000. That is the price this court has placed on my compliance, my silence, my acceptance of arbitrary authority. But I refuse to be silent. I refuse to be compliant. And I absolutely refuse to accept that power without accountability is anything other than tyranny wearing judicial robes. Judge Harrington shifted uncomfortably in his seat, his earlier bravado completely evaporated. His face had taken on a grayish pallor, his hands clasped tightly before him, as if in prayer. His voice, when it finally emerged, was brittle and defensive. This court retains the right of judicial discretion. We are not bound to accept every argument presented simply because it is forcefully delivered or emotionally compelling. Marlene's response was immediate and devastating. Your Honor, judicial discretion does not mean judicial supremacy. The power of any judicial bench exists only within constitutional bounds, only subject to the constraints that generations of Americans have fought and died to establish and preserve. Discretion is not a shield for error. It is not a sword for bias. It is a tool meant to be used with care, wisdom, and humility, never in place of evidence, and certainly never in place of truth. She stepped forward, her presence commanding the entire room. This penalty was imposed without documentation, without physical proof, without witnesses, without any opportunity for challenge or contest. You call it enforcement. The Constitution calls it violation. And the difference between those two interpretations will determine whether this court stands for justice or for unchecked, unaccountable power. Chief Judge Caldwell leaned forward, his voice cutting through the tension with measured finality that silenced everything else in the courtroom. I have heard enough. The words landed like a gavel strike, like the final note of a symphony, like the closing of a door that would never open again on Judge Harrington's abuse of power. Miss Jefferson is correct on every substantive point she has raised. Judicial discretion cannot override constitutional standards. It cannot substitute assumption for fact. It cannot treat official assertion as proof. In this case, we have no supporting documentation, no corroborating witness, no physical evidence, and no substantive foundation whatsoever to justify the penalty that was imposed. His gaze shifted to Judge Harrington with unmistakable weight and undisguised disappointment. This court cannot and should not uphold a fine on the basis of personal interpretation alone. If we do, we set precedent not for justice, but for unchecked power. We abandon the very principles that give judicial authority its legitimacy. Think about what Marlene Jefferson accomplished in that courtroom. She walked in facing overwhelming institutional power, facing a judge who had already decided her fate, facing a $200,000 penalty that could have destroyed her financially. And she walked out having changed the very foundations of how justice would be administered. If one person armed with nothing but truth and determination can make that kind of difference, what might happen if we all refuse to accept injustice when we see it? The silence that followed was absolute, a vacuum where Judge Harrington's authority had once resided. He sat motionless, his hands folded tightly, his eyes fixed on the bench before him. He had been outmaneuvered, out-argued, and publicly corrected by his own superior in front of an audience that would carry this story throughout the legal community for decades. When he finally spoke, his voice was barely audible, stripped of every trace of the commanding presence he had projected at the start of the hearing. This court finds insufficient evidentiary support to sustain the penalty imposed under Municipal Ordinance 47C. The fine is hereby vacated in its entirety. The charge is dismissed with prejudice. Marlene Jefferson did not smile at the ruling. She did not celebrate, pump her fist, or show any visible emotion that might diminish the gravity of what had transpired. She simply stood, composed, and dignified, as if the outcome had been inevitable from the moment she first refused to accept injustice in silence. In many ways, it had been inevitable, not because the system worked automatically, but because she had forced it to confront its own failures, had held a mirror to institutional arrogance, and made everyone present see the reflection clearly. She gathered her documents with unhurried precision, returned them to her briefcase, and walked toward the courtroom doors with the measured stride of someone who understood that this victory extended far beyond her personal vindication. Every eye followed her progress, every person present understanding that they had witnessed something extraordinary, something that would reshape their understanding of what justice means and what it requires. The heavy oak doors swung closed behind her, but the echo of what had transpired would reverberate far beyond that single courtroom, far beyond that single day. Within weeks, the case became a touchstone for reform efforts across the entire region. Municipal offices that had operated with unchecked discretion for decades were suddenly forced to justify their practices, to document their decisions, to prove their claims with actual evidence. The comfortable assumption that official assertions would never be challenged crumbled like ancient walls before a rising flood. Attorneys began citing Marlene's arguments in similar cases across Georgia, Tennessee, Alabama, and Florida. Local governments found themselves compelled to review thousands of fines that had been issued without adequate documentation. The discovery was staggering. Countless citizens had been financially devastated by penalties that could not withstand even basic evidentiary scrutiny. Grassroots organizations seized on the case as proof that ordinary citizens could challenge bureaucratic overreach successfully. Community forums erupted with demands for transparency, accountability, and reform. The momentum became unstoppable, a movement born from one woman's refusal to accept injustice. Law schools began incorporating Marlene's constitutional arguments into their curricula, teaching new generations of attorneys that the law means nothing if it cannot be enforced against those who abuse their power. Legal scholars debated the implications of the case, ultimately concluding that it represented a watershed moment in administrative law, a turning point that would influence judicial practice for decades to come. For Judge Theodore Harrington, the consequences were severe and permanent. An internal review revealed a pattern of similar rulings over the previous decade. Judgments rendered without adequate evidentiary foundation, penalties assessed without proper hearings, defendants silenced before they could speak. He was removed from the bench and assigned to administrative duties, where he could no longer harm the people who appeared before him. But the true legacy of that day belonged to all the people whose stories Marlene had brought into that courtroom. Marcus Henderson, Rachel Okonkwo, William Turner, and thousands more, whose names would never be recorded in legal journals, but whose suffering had finally been acknowledged, whose voices had finally been heard through the courage of one woman who refused to remain silent. The system that had crushed them was being reformed, not through violent revolution, but through the persistent, unwavering application of constitutional principle. Every overturned fine, every revised policy, every new requirement for documentation represented a small victory in the ongoing battle for justice. And at the center of it all stood Marlene Jefferson, who had walked into a rigged courtroom expecting nothing but injustice, and emerged having changed the course of legal history in her region. Her story became a rallying cry for every citizen who had ever felt powerless against institutional authority. It proved that when you question power with knowledge and determination, when you demand evidence instead of accepting assertions, when you insist on due process, regardless of the personal cost, you can indeed change the world. The fight for justice is never truly finished. There will always be those who seek to abuse their authority, who believe that power exempts them from accountability, who treat the rights of ordinary citizens as inconveniences to be swept aside. But Marlene Jefferson showed us something essential and enduring. Even a single voice, armed with truth and unshakable determination, can echo loudly enough to reshape an entire nation. And that is a lesson worth remembering. That is a story worth telling. That is a truth worth fighting for. Thank you for staying with me through every moment of this incredible journey. Stories like Marlene Jefferson's remind us why we do what we do here at Real Tales. Sharing the stories that matter, the moments that inspire, the truths that deserve to be heard by everyone who believes that justice is worth fighting for. If this story moved you, if it made you think differently about justice and power, and the courage it takes to stand up for what's right when everything seems stacked against you, I want to hear from you. Drop a comment below and tell me what part resonated most deeply with your own experience. Your voice matters to this community, and every comment helps us reach more people who need to hear stories like this one. And if you haven't already, please take a moment to like this video, subscribe to Real Tales, and hit that notification bell so you never miss another story. We have so many more incredible journeys to share with you. Stories of courage and resilience, and ordinary people accomplishing extraordinary things. I want you there for every single one of them. Until next time, remember, the fight for justice belongs to all of us. It's not someone else's responsibility. It's not the job of lawyers or judges or politicians alone. It belongs to every person who sees injustice and chooses to speak rather than stay silent. And together, our voices make a difference that echoes far beyond anything we might accomplish alone. Thank you for being part of the Real Tales family. I'll see you in the next story.